like to take a moment before I get started to thank you for your service. The task that you have before you is a daunting one, actually. And you've been called upon to perform your civic duty. And that civic duty is to sit in judgment of another man. And your civic duty is to consider the evidence very carefully and decide in an impartial manner whether or not the state has proven their case beyond a reasonable doubt. And I thank you in advance for this task before you because it was a daunting one. The 12 of you will return to the jury room and you will begin to deliberate and begin to determine and ultimately make the determination of whether or not the state has met their burden of proof. Not whether the defense has proven innocence, not whether the defense has somehow tricked you, not whether the defense has confused the facts, but whether the state has proven Andrew Romero's guilt to these crimes beyond a reasonable doubt. You were chosen from among hundreds of jurors. And you were chosen because you're qualified. You're qualified. You told us during voir dire that you could be impartial, that you would judge the facts based not on what you perhaps had seen on television or talked about with family members, but based on solely what you heard from the witness stand, based solely on evidence that Judge Eichwald deemed admissible, and based solely on what came out of witnesses' mouths or was shown to you during the course of the last 3 weeks. Each one of you took a solemn oath. And quite frankly, each one of you promised that you would serve in an impartial manner as required by judge's instruction. And quite frankly, now's the moment for you to make good on that promise. And I know you will. We know you will. We know that you will judge this case based not on emotion or fear, but based solely on what you've heard over the course of the last 3 weeks. You know, we live in a great society, a society governed by laws. And it is the jury system, it is trial by jury that separates defendants. Not only Andrew Romero, but everybody charged with crimes from mob justice. It is our system that has survived for some 200 years, through good times and bad, that guarantees defendants, like Mr. Romero, he has the right to remain silent. He has the right to counsel. He has the right to the presumption of innocence. And he has the right to trial by jury. And that's why we're here. And quite frankly, it is a terrible and awful thing to be accused of a crime. It is most terrible and awful to be accused of killing a police officer. The very power of the state you've seen during the course of the last 3 weeks, the power that the state can bring to bear on an individual was made oh so clear this last 3 weeks. APD, Rio Rancho Police Department, the FBI, the New Mexico State Police, on and on and on. And it is this burden, it is this vast amount of power that the state has the ability to bring to bear that justifies this burden of proof. With the equality of power so shifted in favor of the state, this is the very reason that we have, and it is required, this burden of proof, that the state be made to prove a defendant Andrew Romero's guilt, not the other way around. It is this imbalance of power that justifies this burden of proof. When a prosecutor takes the podium and immediately begins to talk about counsel for the defense trying to confuse the issues. One of the first slides you saw made reference to a red herring. Your ears should be perking up, and you should be paying close attention, because this signifies one thing. The state is terrified of their own evidence. The state is scared of what their evidence shows or what it doesn't show. No matter how much Miss Romo wants her evidence to show you something, no matter how argy she hearts, no matter how much finger wagging and finger pointing and scowling and pointing at the defendant takes place during her closing argument, that doesn't make her case any better. There is certain undisputed evidence in this case, and the state must live with that evidence in their quest, in their desire to prove guilt beyond a reasonable doubt. And I submit to you as we go through this, as I present my argument, if you haven't already come to the conclusion in your mind, you will see that the state's case is a failure. I know that each and every one of you felt emotion, pain, anger when you see these photographs, this video footage of Officer Benner laying dead or dying. You would not be human if that didn't stir some awful, awful emotion, some sorrow for his family. And please don't mistake anything I say during the course of this closing argument to be even remotely disrespectful of Officer Benner. It's not. We live in an adversarial system. I operate within an adversarial system. I'm tasked with defending Mr. Romero. That doesn't mean you will ever hear me deride or put down or somehow malign the memory of Greg Benner. He was an honorable man. He served his country well overseas, and he died in the service to his community. That's an honorable thing. This case is not about the honor or lack thereof of Greg Benner. It's about who shot him. And I know, and you've promised us, that you can, one, sift through the emotional impact of a picture and a video of a dead police officer. That doesn't answer any questions. It makes us sad, but it doesn't answer the question, who shot him? I know that you're able to sift through days of testimony that didn't offer a whole lot. Fingerprint evidence that shows nothing. Tire track evidence that shows nothing. Comrades of the fallen officer who told you what a good guy he is. Yeah, he was. But those hours of testimony didn't provide a whole lot of evidence as to who his killer was. And finally, I know that each and every one of you as jurors will focus on the evidence that either does or does not connect Andrew Romero with this murder. Now, I want you to be cognitively aware and resist the temptation to burden shift, to somehow require the defendant to prove his innocence. To say, well, the defendant put on witnesses. That must somehow make them responsible for proving that Andrew didn't shoot the officer. No matter whether we put on one witness or no witness, or a case takes 15 days, that doesn't change the burden of proof. It doesn't shift the balance of power, and it doesn't in any way diminish the requirement, which will be given to you in the jury instruction, that the state prove guilt beyond a reasonable doubt. Ms. Romo made reference to the pistol, Beretta, and she indicated that I didn't seem to be contesting that that's the murder weapon. I'm not. We're not. The Beretta is the gun, the weapon that killed Greg Benner. Steve Guerre is a smart man. He knows his firearms. But no matter how much evidence you have about the Beretta, no matter how much you know about how it fires or how many rounds, rounds will fit in that magazine, or even the ejection patterns, that doesn't tell you who pulled the trigger. In fact, throughout day after day after day of scientific testimony, you still have more questions than answers. And we live in an amazing time for science. We live in an amazing time when we can rely on pieces of evidence smaller, what, 1,000 times smaller than the head of a pin. Microscopic traces of fingerprints, whatever it may be. We can rely oftentimes on these pieces of evidence to help us solve crimes. In this situation, forensic evidence perhaps raises more questions than answers. DNA does not solve this crime. There was no shooting reconstruction to show how or where or even when Officer Benner was shot in relation to who shot him. Fingerprints, no answers. Medical evidence, no real answers. Tire tracks, nothing. Ballistics, nothing. Science does not solve this case. Science does not prove beyond a reasonable doubt anything in this case. As I said a moment ago, DNA science is an amazing thing. You have two well-qualified DNA experts, and really, besides perhaps the method by which the DNA was analyzed, we don't take issue with the two primary findings that the state has offered to you. One, that Andrew Romero's DNA was on that pistol. And two, Andrew Romero's DNA is on that steering wheel. You know that on the pistol, there was a match to Andrew, but there was also one or more DNA samples. Can't say who the other person was. And you know on the steering wheel, Andrew and Tabitha, and at least one other person. Don't know who the other person is. But you know that you can never date a DNA sample. You can't say that DNA sample of somebody who touched this podium was left at a certain time. You can't pinpoint when it was held or who or under what circumstances. So really the DNA tells you two things. Andrew Romero handled the gun at some point in time, and Andrew Romero touched the steering wheel at some point in time, and that's it. That's as far as it goes. To speculate or rely on conjecture would not only be wrong, but it's contrary to the rules and the jury instructions that you will receive. In fact, Mr. Guietta, again, I can see he's a very smart man. He made an important point about reaching conclusions that perhaps improper. And when I asked Mr. Guietta about GSR evidence, gunshot residue evidence, he said, you know, we don't do that anymore. APD doesn't do that anymore because the presence of a chemical on somebody's hand doesn't tell us if that person actually fired the gun. And when I asked him about DNA over the objection of the state, he said, yeah, that's exactly right with DNA as well. It tells you that the DNA is present, but it doesn't do anything else. And to reach said conclusion that just because your DNA is on an item doesn't mean that person pulled the trigger. So for the state to suggest that because Andrew Romero's DNA is on that gun, he must have killed Officer Benner is nonsense. Nonsense. That relies you to speculate, to engage in conjecture, to suppose whatever. It's just not a fact you can rely upon except to show Andrew touched the gun and he touched the steering wheel. That's it. The firearm forensics offers some important evidence, we believe. It doesn't solve the case in any way, but it offers important evidence for you to consider. The wound on Officer Benner's leg, near his knee, was through and through. It was front to back and up to down. Now remember, through and through, down to up, front to back. He was shot in the back of the leg, from a low position to a high position. That's not what our experts say. That's what the state's expert says. The other two wounds, left shoulder in the back, right shoulder blade in the back. When the state says the officer was shot in the back, absolutely. I'll move to why that's so important in a moment, but we take no issue with the fact that Greg Benner was shot in the back. There were 4 shell casings in this case. All of them recovered on the street. No shell casings in the Durango. And the shell casings were actually grouped together in a fairly close pattern. And there were 4 projectiles, or parts of projectiles, recovered that were matched to these casings. 2 were removed from the officer's body. 1 was found on the street, and the argument by the state, and I have no objection to this, is it was one on the street was a through and through, and the one was in Tabitha Little's foot. And when you recall what the forensic evidence is, the leg wound, the down to up, that took place. The muzzle was located with between 2 and 6 feet from the officer's leg when that was fired. 2 to 6 feet. We're talking about a very, very close range shot. I'm 6 feet tall. So the total length of distance between where the end of the muzzle was when Officer Benner was shot and where his leg was located where he was standing was between 2 and 6 feet. The back one, he didn't see what was coming. Otherwise, this is an officer, he's been in the service, he was overseas in the Army. He's an officer on the force, he's well armed. If he'd have perceived a threat, perhaps there would have been evidence that he attempted to draw his weapon, his taser, his baton, something. He had his cuffs out. So when you go back to the jury room to think about this and deliberate, you know from the state's evidence that he was shot in the back with no time to prepare and no time to defend himself. Now the shell casings, the state is putting forth a theory to you that Andrew Romero shot from either inside the car or near the car or outside the car. The shell casings don't suggest that at all. You know from the forensic science that this Beretta will eject a shell casing 2 feet back and 2 feet to the right. Now, while shell casing evidence is not an exact science by any stretch of the imagination, you see the pattern of the shell casings on the ground, and you can reach some reasonable conclusions about perhaps the location of the gunman or the gun person. But it could not have happened as the state alleges. Remember, Mr. Officer Benner was shot in the back. And you'll see the acceleration marks from the vehicle. And you see the recreation photographs when the officers took another car and put it in front to replicate where the vehicles were during the shooting. And you see that those shell casings in no way match the state's theory, and they in no way match Tabitha Little's story about how all this went down. It simply couldn't have happened as the state's, I'll call it, star witness has suggested. And these are items of evidence that you must look at very closely. Because these items of physical evidence, of forensic science, must be taken in conjunction with the eyewitnesses in this case. And you've got some decent eyewitnesses. Some, perhaps, help the state's theory. Others do not. And you can't disregard one over the other. You can't pick and choose. The evidence must be taken as a whole, taken in conjunction with each piece together until you have a picture of what you believed happened, what you believe happened. Barbara Myers, the woman who was sitting in the Xterra across the parking lot, is an important witness. The state thinks she's an important witness. We do too. She's totally independent, off duty, at the park with a friend, hears shots, looks in her rear view, and sees a vehicle speeding off and one woman standing outside the car. She has no motivation to exaggerate. She has no motivation to not tell the truth. Good Lord, I'm sure she didn't want to be there on her day off to see a police officer dead. She told you what she saw. Hears shots, sees a woman standing outside the vehicle or a vehicle, and sees that vehicle speed off. She saw no man standing outside the vehicle. She sees no other person running off. She sees no one getting in or out of said vehicle. She told you what she saw, and she has no reason to lie. And she says when she heard the gunshot, she was looking very closely. James Salter. Salter told you what he thinks he saw. Comes into court, and for the first time since the shooting, points at Andrew Romero and says, "That's the guy. I remember him. I remember that guy." Problem with eyewitness identification is this was something that happened 18 months ago. My client has been on the news quite a lot in the last 18 months. The Rio Rancho Police Department never offered the opportunity to, hey, look at these photographs to see if you can recognize somebody here maybe. So what's he to do? This is a man who wants to help. He knows the defendant's going to be sitting at that table. He knows if he says anything but that's the guy, the state's case is circling the bowl. So what's he to do? Yeah, of course he does. His wife, on the other hand, who, when you remember where they're sitting in the car, the wife had the better look. She had the better view. He's driving. She's in the passenger side. She certainly didn't say, Andrew's the man. She said is, short hair and skinny. That's it. You certainly didn't hear the state asking her to make an in-court ID, although she had the better vantage. An amazing moment in this trial was when Miss Andrews, the store clerk, takes the stand and says, "That's the guy sitting right there. Andrew Romero is the guy I saw in my store just a few minutes before the officer got killed. And I remember because he was acting sketchy with that girl, acting kind of weird and milling around my register." And when asked if she'd reviewed the video that you saw and you have in evidence, "Yeah, I looked at it, but I didn't see him." And I went back to look at it because I wanted to be right. I wanted to make sure I got it right. And there were 10 camera angles, and she didn't bother to look at any of the other 7 camera angles. And what you have before you in evidence are stills of Tabitha coming in and out of the store, of Tabitha at the register, and an outside view of Tabitha walking to the vehicle. And most shocking is, again, the state's star witness tells you Andrew never went in the store. So what does that say? Well, I submit to you that it calls into question the validity of any in-court identification by Ms. Andrews. Again, she certainly wants to be helpful. But when the government's primary witness says he didn't ever go into the store, he stayed outside and put gas, you have to wonder, not about necessarily the integrity of these witnesses who pointed Andrew, that's the guy, but whether or not what they remember is accurate. Another important witness to think about is Enrique Lewis. Like Ms. Myers, he is absolutely independent in this case. He wasn't doing anything except walking home from work. He called the Rio Rancho police and couldn't get through. Called the next day and said, "Hey, I think I've got something important for you. This car almost ran me over, and I think it might be connected to the police shooting." What's the driver look like? Hispanic or Italian, dark short hair, couldn't really see a whole lot more. Was he ever presented with an opportunity for a show-up or a lineup? No. He didn't make an in-court identification, but he did something remarkable. And not at the hands of the state. He was presented with a picture of Michelle Candelaria. And he looked at that and said, that could have been the driver. Now, when that happened, you hadn't received a whole lot of information yet, so I'm sure none of you knew the significance of Michelle Candelaria in this case. That became ever so clear as we moved through this. But what's most important is that Mr. Lewis gave you the possibility, presented you with an alternative that flies in the face of the government's case, that maybe, just maybe, Andrew Romero was not driving the Durango. Maybe, just maybe, Tabitha is a liar and a junkie and a fool. And just maybe she made all of this up to protect herself and her other junkie buddies. It's not a crazy idea. And it's not a crazy idea because you have eyewitness evidence that supports this. Not that the defense has to prove it to you, but these are facts that are very, very damaging to the government, to the state's case. Tabitha Littles. Miss Little's involvement in this case, her progression of lies began early on. The moment she made contact with anybody who would talk to her, she started flapping her mouth with a story. And that story changed over time, over time, over time to fit her needs. I'll talk about the progression of that story in a moment, but you heard her. I think she's given at least 7 stories, if you include Officer Manifolo that came to talk to you yesterday about the shooting inside the car. But no doubt, her story has changed over time to fit Tabitha Little's best interest. What Tabitha Littles told you during her time on the stand while conveying to you her truth this time, she was behind the officer. Well, she confirmed that she was at the scene. She confirms that she was outside the vehicle. She confirms that she was in a position behind the officer. She confirms that the officer gets down from his vehicle, runs past her, says, "Are you okay?" has his back to her as he's on the way to the Durango. She confirms lie after lie after lie after lie. She confirms to you that she has absolutely everything to lose. Everything. She confirms that she's a junkie, not only that day, but every other day of her life. That she starts the day by smoking meth after having been up all night for day after day after day. And she rises to meet the day by smoking meth and getting in the shower and going and planning robberies. And she confirmed that she reached a plea deal with the state that would allow her her life. And she confirmed that had she not reached said plea deal, she would have left Penitentiary of New Mexico in a box. She would die behind bars. That's quite a lot of incentive to fabricate a story. That's quite a lot of incentive to cooperate. It's certainly incentive to get yourself out from a pretty deep hole. And she did it. Tabitha Littles is a degenerate junkie with a long criminal history, including armed robbery, trafficking methamphetamine, possession of methamphetamine, and escape. She had methamphetamine on her when she got out of the vehicle. She knew she was going back to jail if she got caught with the methamphetamine. She inserted it in her vagina so she could get high at the hospital. This is a person with so little care and thought of others. While she's getting high at the hospital, as Officer Benner lay dead a few doors down, she has the audacity to ask the nurse to put on makeup for her crime scene photograph. She uses meth to help her with her memory in one story, but in another, her story, her memory was clouded because she was so high and zonked on drugs. And now the state will argue, and already has, that, well, wait a minute, Andrew's just as bad. He's a degenerate junkie too. He's a criminal, he did all these robberies. Well, guess what? Andrew is not the star state witness who they intend to use to prove their case. You're not being asked to rely upon the testimony of Andrew Romero on the witness stand to prove the government's case in chief. These people are not similarly situated. You've seen evidence about Andrew committing robberies. You've heard testimony about him. He's a junkie. He robbed stores. That does not make him a cop killer. That does not make him a murderer. The progression of Tabitha Little's story goes something like this. Initially, she was carjacked by two people, a man and a woman. Told that to several people, including civilians and fire personnel. She gets to the hospital, she changes. Then it becomes, my boyfriend kind of kidnapped me. Then, maybe I wasn't kidnapped by my boyfriend. Maybe I was just along for the ride and he was doing everything bad. Then it was, I didn't really know what was going on. Then it was, after she realized that she was in a hook, and after attempting to bargain her way out of this was going to fail, then she said Andrew Romero intended to kill the cop. That's what she told Steve Montano. But you must remember during this progression that Andrew Romero's name only comes up when Tabitha thinks, when Miss Littles thinks that she has negotiated herself a free walk. Over and over again during her testimony, am I going to go home? Do I get to go home? If I tell you the name of the person in the car, am I going home? Do I get to go home? Is nothing going to happen to me? And then and only then does Andrew Romero's name even come up. And that's important because she is the link between the death of Officer Benner and Andrew Romero. And it wasn't until she thought she'd worked out her little deal with the cops, and she felt oh so betrayed later when they charged her and arrested her, but it wasn't until she thought she'd worked out a walk that Andrew's name comes up at all. And when she realized that she's on the hook for the death of a police officer, she negotiates the real deal of the century. And I think this is a deal of a lifetime. Miss Romo could have put words in my mouth. Miss Little started off equally situated with Andrew Romero. Life without the possibility of parole, plus over 100 years, plus immunity for first-degree trafficking, plus first-degree trafficking that she's already admitted to, plus robberies that she's admitted to, dozens and dozens and dozens and dozens of years on top of a sentence that would have included her natural life. So when I say leave prison in a box, you know what I mean. And Tabitha, in exchange for this deal, testifies, as Ms. Romo characterized it, truthfully. The deal that she got and the math on that deal is phenomenal. And it's important to remember what she testified to. Not me, I didn't make this up. She pled to 18 years in jail. You divide that by 2 for good time. With credit for time served since she went into custody, running concurrent with her probation violation sentence, which is about 2 years, and Miss Little's for all of her involvement, which potentially includes the murder of a police officer, she's going to do 6 years on top of what she's doing now, the 2, behind bars. That's it. She had everything to lose, and oh my God, I want to be a mom again. I care so much about my kids. Well, she saved her sorry life. And she did it by cooperating with the state and telling the state what they wanted and needed to hear. But Tabitha Little's truth, this time on the stand, doesn't particularly help the state when you look at her testimony from a forensic standpoint. Because you now know, and it has been confirmed, that indeed she was outside the vehicle, which has been confirmed. She was behind Officer Benner when the shots were fired, which has been confirmed by her own testimony. She never sees Andrew Romero get out of the car. She's not injured when she is thrown from the car. Officer Benner runs past her. She's the person behind him who has the drop on him. And Andrew drives off. Now, for you to believe Tabitha's story that Andrew Romero somehow killed this officer, if you believe her story, you have to suspend your belief in reality. You have to suspend the laws of physics. You have to suspend the laws of quantum mechanics. Because the only person behind Officer Benner was Tabitha Littles. But she tells you that Andrew Romero somehow shot the officer in the back from a position the officer was facing him from the car or from near the car, which is impossible. Absolutely, utterly impossible. And again, the burden is not on the defense to prove the impossibility. The state's burden is to prove that it happened, that Andrew shot the officer. And that does not jive with what you know to be true. The forensics you know to be true do not comport with Tabitha Little's testimony, period. Tabitha started off telling crazy stories. Let me propose another crazy alternative. Tabitha's out of the car. She has the gun. Officer Benner runs past. She knows she's going to jail. She shoots him in the back. She tosses the gun in the front seat, and someone drives off. Now you say, well, doesn't that require supposition and conjecture and speculation? Sure it does. But at least that theory, that crazy alternative, complies with the laws that govern our natural world. It complies with the laws of physics. Tabitha Little is the only one behind this officer, and she shoots him in the back. And you asked, Ms. Romo said, Tabitha Littles didn't shoot herself in the foot. Well, nonsense. There's no evidence of that. There's no evidence of Tabitha not being able to shoot her in the foot. In fact, you know it was a ricochet, and you know it was an angle. But there's no reconstruction to suggest or rule out that Tabitha blasted herself in the foot. She didn't shoot herself in the top of the foot, but you know it's a ricochet. So why is it so crazy? She knows how to use this gun. She knows how to aim it and pull the trigger. She says there's one in the chamber. What's so crazy about her shooting herself in the foot? Gun goes off, pointed at the ground, and it ricochets. There's not. And the state has done nothing to ever rule that out. You would think perhaps that there might have been some attempt to judge the angle of the entry wound to her foot. But of course not, because that doesn't comport with the state's theory that Andrew shot her. Bottom line, ladies and gentlemen, is that in order to prove Andrew Romero guilty beyond a reasonable doubt, you must believe Tabitha Littles. You must believe her testimony. And if you don't, if you believe she's not telling the truth, if you believe she's lying to you about anything, then the state's theory is based on perjury. The state's theory that Andrew Romero committed these crimes is based on lies under oath. It's called perjury. And the existence of perjury totally undermines the idea that the state has proven guilt beyond a reasonable doubt. Either Tabitha Littles is credible or she is not. Either she's telling you the whole truth and nothing but the truth, or she is full of it. Either she tells you the sworn truth or she has committed perjury, and you can't have it both ways. If you don't believe Tabitha Littles, that in and of itself is paramount to reasonable doubt. Now, much was made of the car keys. And when Mr. Romo says that, boy, Tom Clark, he made a lot of these car keys, well, I certainly did. So did Miss Leo's, because it's an important detail. And I can't explain why one officer said there's no photograph and another showed you that there was. And one officer says, I took these keys into custody, and another says, well, I don't see that on an affidavit return. And one says they were checked into evidence, and then the evidence log says that those keys weren't turned in until October. And one officer says, yeah, they were sitting in the sergeant's office for safekeeping. I don't know. But the possession of those car keys is an important detail, because those car keys are the link, or a link, between the person who was driving the vehicle at the time Officer Benner was shot and the Durango. And the fact that those car keys do not ever get checked into evidence under AR6, and they show up in evidence with a separate number as 81.
I'm sorry, you misspoke.
I did not misspoke. I did not misspeak.
I'm sorry, may we approach? Please, Mr. Clark.
On the evidence receipt included phone cords, cigarettes, miscellaneous. That's what appears to have been entered into evidence at the Rio Rancho Police Department. Item number 82, I misspoke, was the car keys. You have the exhibits. You don't have to rely on my memory. You have the exhibits. You look at the evidence log that shows item number 82, and that was checked into evidence in October. May, June, July, October. That car key got placed into evidence approximately 90 days after the shooting. What does it mean? Judge for yourself. But I'm telling you, the possession of those keys, not the fact that they are now in evidence, but who they came from, is pivotal in this case. The recorded statement. Recorded statement is ugly. Recorded statement, Andrew's voice. Recorded statement, what about what's her name? Did I really shoot her? I ask you to listen to that very closely. That is a question. Listen to the intonation in Andrew's voice. He's asking you a question. I'll tell you, if you think that that statement, that recording is proof beyond a reasonable doubt, I've already lost you. You've already made up your decision, and there's nothing I can say to change it. But you must look at that recording in conjunction with everything else. That recording is not proof of anything beyond a reasonable doubt, other than Andrew asking his aunt a question. But listen to it closely. It is a question. He appears to be somewhat flippant. That's not a great detail. But you must look at that in conjunction with everything else, because that recording in and of itself says nothing about shooting Officer Benner. It says nothing about murdering Officer Benner with some sort of depraved intent. He asked a question regarding what's her name. Now, the elements of first-degree murder, and you'll get the instruction. The state has to prove that Mr. Romero killed Officer Benner, that the killing was with deliberate intent to take away the life of the officer, and this happened in New Mexico on the 25th of May, 2015. Then you receive the instruction on what deliberate intent is. And the state gave an example of deliberate intent can be formed in the time it takes to read this paragraph. Well, that's not an instruction anywhere. You're to use your common sense, and you make the determination from the evidence you have at hand, number one, whether it was indeed, in your minds, proven beyond a reasonable doubt that Andrew was even the gunman, and two, did he do so with deliberate intent? The difference between first-degree murder and second-degree murder is that deliberate intent. I thought this over. I planned it out. I weighed the consequences back and forth, and then I took action. That's deliberate intent. And you also have an intoxication defense. Ms. Romo talked about that. How could this guy be, how could he lack the intent to kill? He's a functioning junkie. You know the evidence. Based on whichever story that Tabitha is telling on whatever day, he's either shooting heroin right before the shooting, or he's shooting meth and heroin in the form, injecting it both, or he's smoking meth. And I got to tell you, in 20 years of practice, this is the first time I've ever heard the state argue that someone who is shooting heroin, smoking meth, or shooting meth and heroin is in their right mind. Use your judgment about, in your experience, what shooting dope does to you, what shooting heroin and meth does to you, or what smoking meth does to you. Tabitha, in at least one of her statements, said, I was so blown out of my mind, I didn't even know what was going on. She testified that Andrew was fixing up a shot right before, and was fixing up right before they were to rob the Twisters. You have evidence of intoxication. You have evidence also from Tabitha, Andrew didn't intend to kill anybody. It just happened. It happened like that. And again, this goes back to whether you believe Tabitha or not. But you can't pick and choose. Either you believe her story or you don't. And laying this off on Andrew certainly is consistent with her initial lies to protect herself. Second-degree murder is the killing without deliberate intent. A murder that just happens. And you have the instructions. It's a murder it's a killing that is not premeditated. So for you to find the defendant guilty of second-degree murder, number one, you have to decide he was indeed the gunman. You have to believe Tabitha Little, every word of her statement. And then believe that Officer Benner died as a result of Andrew's actions. I submit to you that it is impossible in this situation to draw such conclusion. Now, there are a couple other jury instructions that I'd like to point out. I've mentioned the words speculation, guess, and conjecture a moment. Jury instruction number 3 prohibits jurors from relying on, and it says specifically, your verdict should not be based on speculation, guess, or conjecture. Neither sympathy nor prejudice should influence your verdict. You can't guess. Ms. Romo stood before you and asked you to guess on so many things. His DNA is on the gun, he's the gunman. His fingerprints are in the car, he's the driver. Nonsense. The jury instruction prohibits you from guessing or speculating or engaging in conjecture. You must rely on the evidence that you have before you, and that only. You can't make any reference to the fact that the defendant chose to remain silent. In fact, instruction number 12 says you must not draw any reference of guilt from the fact that the defendant did not testify in this case, nor should this fact be discussed by you or enter into your deliberations in any way. Each of you told us during voir dire that silence wasn't a problem. There are lots of reasons people don't testify. none of which have to do with guilt or innocence. So I ask you, I hold you to your promise. Follow the jury instruction. And don't consider the fact that Andrew has not taken the stand or not. It's not important. A reasonable doubt instruction goes like this. This is instruction number 2. The law presumes the defendant to be innocent until or unless you are satisfied beyond a reasonable doubt of his guilt. The burden is always on the state to prove guilt beyond a reasonable doubt. It is not required that the state prove guilt beyond all possible doubt. The test is one of reasonable doubt. A reasonable doubt is based upon reason and common sense. The kind of doubt that would make a reasonable person hesitate to act in the graver and more important affairs of life. More important affairs of life. Perhaps the decision to get married, decision to buy a house, decision to have children, decision to have surgery. And I submit to each and every one of you that nobody sitting in that jury box would ever base their decision on a graver and more important affair in your life on the word of Tabitha Littles. If you go back to the jury room and you ask yourself, there's a lot of unanswered questions, that's reasonable doubt.
Your Honor, may we approach?
Questions about the elements of the crimes, whether it's murder, or whether it's shooting at it from a motor vehicle, or whether it's tampering. If you have unanswered questions, that's reasonable doubt. If you find Tabitha Littles not credible, that is reasonable doubt. If you find yourself thinking, I just don't know. Maybe he did it. Maybe he killed Officer Greg Benner. Maybe he didn't. I don't know. That is reasonable doubt. I thank you for your time. Thank you for the task before you. I thank you for patience with us over the course of the last 3 weeks.